Good afternoon, Miss Beneke.
Good afternoon, DCJ.
Did I pronounce your surname correctly?
You did, yes, thank you.
Thank you. Welcome to this session of the JSC interviews, and thank you for availing yourself for consideration.
It's my pleasure.
Yes. You hold the degrees of LLB and LLM, is that correct?
That is correct, sir.
You obtained both of them from the University of Port Elizabeth.
As it then was, yes.
As it was then called. Yes. And you started your career as a teaching assistant at the university, at the same university, is that right?
Yes.
And then in 2003, you did pupillage between July and December.
I did.
And you later became an external examiner for Rhodes University as well as Nelson Mandela Metropolitan University.
Yes, sir.
Yes, and when were you admitted at the bar? Is it 2004?
No, 2002, 28 September, I think.
Yes, and you started
sorry,
practicing
28 February.
And you started practicing as an advocate immediately?
No, I did my master's in international criminal law.
Yeah.
And then I was called to the bar in 2003 when I finished my pupillage.
And have you been practicing as an advocate since then?
Ever since.
Without interruption?
Without.
Yes. Can you share with the commissioners what types of cases your practice gave you over the years?
Yes.
In terms of branches of law? Yes.
I set it out in some detail in the application, but I'll summarize. I did work in all fields of law. As a junior, one starts off in unopposed motion court, and I devilled quite a lot in contract and delict, and then later on I developed my own practice in both of those, both in the magistrates court and in the high court. I did some work in admin law and one or two matters in labor law, but predominantly contract delict, the run-of-the-mill stuff that one finds in Port Elizabeth.
Did your practice include competition law, commercial law?
I did some commercial law, not much. Competition law, I recall doing some deviling in a competition matter, but I don't recall doing anything save restraint of trade as far as competition went.
Yes. So what branch or branches of law dominated your practice?
Civil. I did predominantly civil law. I would say starting off, the vast majority of my matters were MVA, road accident fund matters. Right at the beginning, I also did quite a bit of legal aid work, criminal work. Most of those related to rape charges. That stopped in about 2005 when the Legal Aid Board changed its policy on how to brief counsel. It had to do with what percentage of one's practice was criminal, which determined which court one could practice in. And mine was of such a low percentage of criminal law that I could practice in the district court, despite having done 3 or 4 years of high court rape trials. But anyway, so I abandoned the criminal law and focused predominantly on contract law, stuff like leases or building disputes, matters of that nature.
All in all, you have practiced for about what, 20 years?
It's about 17 and a half, nearly 18 years.
Yes, okay. And when did you take silk?
2019.
Yes. Okay. And you have acted as a judge as well?
I have for 3 months.
Yeah. And how did you find that?
Like coming home.
Yes.
As counsel, what we do is we analyze the facts and the law and hope to put the best version before the court. So when I came to act, it was a continuation of everything that I'd been doing up to that stage. And whenever I had difficulties, as one must when one starts something new, the permanent members of the judiciary were always there to assist me whenever I had problems.
Yes. Judge President.
Good afternoon, Advocate Beneke.
Hello, JP.
Have you ever presided over a case running, say, for something like a term, gruesome sort of murder case?
I have not.
In light of the disclosure you've made regarding your state of health,
Yes.
would an extended acting stint involving allocation of work, such as I have alluded to, help the constituency and yourself establish that you can rise to the occasion in spite of the challenge you mentioned in the form?
I have no doubt that an opportunity to do something like that would obviously provide more evidence. What I can say is that I sat through innumerable rape cases, predominantly in respect of minor children, when I started my practice, and that was before I was treated for my anxiety and my depression. And I coped just fine. I had no problems there. My anxiety and depression is unrelated to the nature of the work that I do. It's an underlying general anxiety. When I am busy, I find I actually remain more calm. I don't have time to become anxious about the smaller details of my life, which is usually where my anxiety manifests. But definitely, any opportunity to show that I'm more competent or capable would be welcomed. But I don't foresee it being a problem. It hasn't to date.
Yes, Advocate, the issue is not about your competence,
Yes.
but it's about demonstrating to all and sundry that in light of the disclosure you have made, the concerns around that,
Yes.
for you to prove it to everybody that you can rise to the occasion, in the sense that you can run a marathon trial,
Yes.
running something like 3 months, 6
Yes.
months, which often happens
Yes.
in Port Elizabeth,
Yes.
and sometimes
Definitely.
at the other centers
Yes.
within the division. Thank you, ACJ.
Thank you, Judge President. MEC Gade.
Judge President, good afternoon. I don't have a question.
Thank you. Commissioners, Commissioner Jesse.
Good afternoon.
Good afternoon.
Advocate, you are English. What African language can you speak?
I am presently learning isiXhosa.
When have you started learning?
Well, the truth be told, I started in Standard 3, but by Standard 5, I abandoned it. And more recently, I decided that it is prudent to speak the language of the people in whose area I live. Fundamentally, many of my friends are posting WhatsApp social statuses, and I can't understand them, and that's my own friends. And so I took the decision that it would be prudent to learn it.
Now, there's generally women in the profession have suffered from lack of briefings.
Yes.
They don't receive briefings, they have been undermined, or just overlooked for reasons that they are women.
Yes.
I hear your practice, you done commercial competition or what have you done to ensure that women, in particular black women, do access such lucrative work that you are exposed to?
Yes. Whenever I come across a brief in which I believe that a junior, particularly a black woman, would be able to learn, I approach my attorneys and ask them if it would be possible to bring on a junior. If the attorney says that the cost will be too high for the client, then I offer to do it on what is called a senior-junior mentoring basis, which is basically where I give a portion of my rate per hour to the junior. And I've done that in quite a few matters.
Have you done that?
I have, yes. I've got presently, I think, 2 or 3 black female juniors that I've brought on where I'm sharing my fee with them so that the client doesn't pay.
Lastly, I've just noticed that you probably have done criminal trials
Yes.
at your early stages
Yes.
in the profession. And for sometimes you have not done any criminal case.
Yes.
Would you regard that you are properly equipped to preside over criminal cases, or is that an area that would need some improvement?
I may say that I haven't sat on or in a criminal trial for quite some time. Having said that, I am quite involved in pupillage and help train the pupils in respect of criminal law. I've also devilled for a number of silks and senior juniors in criminal matters on important procedural points.
Thank you. Commissioner Schlemmer.
Thank you, CJ. Good afternoon, ma'am.
Hello, Prof.
I see from your CV and the questionnaire that you've been involved at the university as an external examiner.
Yeah.
And I just want to say thank you for the assistance that you provide to academics in this regard.
It's a pleasure.
I think it is important for practitioners also to show their interest still in the development of our students. Now, on another note, when you applied now to become a judge in the High Court, can you tell us what your judicial philosophy is?
My starting point when I'm sitting in a matter is to write for the litigants. I attempt to discern the dispute and to settle that according to the law. However, I am aware that the law is not as perfect as it could be and can be developed in light of the Constitution. Where that is necessary, I would do so. I haven't yet come across an opportunity to develop the law in that way. For the most part, matters in which I've sat have been solvable on the law as it stands. So that would be my judicial philosophy.
And what is your understanding of the doctrine of separation of powers?
Separation of powers is a fundamental principle of our law in that it guarantees the executive, the legislative, and the judiciary their own spheres of influence and power. However, it is fundamental that each of these 3 balance each other. The place that this comes most to the fore, of course, is with the judiciary and the judicial oversight. And so that is where most of the friction seems to occur. But as long as judges follow the precepts of the Constitution and don't overstep the bounds, then the balance of that separation of powers ensures should be maintained.
Thank you. Commissioner Nyambi.
Thank you, ACJ. Afternoon, Advocate.
Good afternoon, Commissioner.
I will ask you just one question.
Yes.
As somebody available to be a judge in the Eastern Cape Division, any particular significant thing that you would think it's a challenge in that division? Should you be appointed to assist JP and the entire division that you have experienced on your acting stings? Share with us.
A fundamental challenge that I've noticed is technological infrastructure. It is exceedingly difficult, and I don't know, frankly, who's to blame, if it's ESCOM or if it's service providers. But on occasion, internet resources won't be working. It's difficult to have a video link court if you don't have the facilities. That is important. I know that case lines is being well used in other divisions, and I think it would be a good idea to think about bringing it to the Eastern Cape. Those two are as far as technology goes. Insofar as other difficulties, and the JP, bless him, has done his best to ensure case flow management works to the best of his ability. But I think an enforcement of the rules of court would go a long way to making matters run on schedule and as quick as possible. If one just followed the rules, the DAs are prescribed and matters could come before court much quicker. And I'm sure that's what the JP is attempting to do with these case flow management processes.
You missed the part of what you will do yourself.
Well, I'll sit with the JP and talk to him about these things that I've experienced in other divisions and how they work. That's the best I can do. I think as a judge, one has very little power over the technological or electrical or public works difficulties that one encounters. One can only do what one can do with the resources one has, and I'll support the JP in anything that will help court flow more smoothly. But I mean, save in the three respects I've mentioned, I have nothing right now that I can think of.
Thank you, Advocate. Thank you, ACJ.
Thank you. I have Commissioner Mtolo Zepu coming next. After that, it will be Commissioner Moimang. And then I'll go to the commissioners on the virtual platform. And unless somebody feels strongly, okay, I will add one because she hasn't asked in a long time. So, but after that, that's Shabangu Ndawe. Thank you.
Okay, thank you, Acting CJ, and good afternoon, Advocate.
Good afternoon, Commissioner.
You know, what I just want clarity on is, you know, when we were doing the consultations for the legal sector code,
Yes.
countrywide, and so, where our concern was that SCs don't do enough in the way of training, but don't do enough in training the pupils, and
Yes.
we were informed by that SCs don't take pupils.
Yes.
But then they kept on saying the deviling is actually empowering young advocates.
Yes.
But the issue I have with it may be good. I want you to explain deviling for me to
Yes.
understand, so that when we finalize whatever we recommend, that it be part and parcel of the SC's empowerment tool in the
Yes.
code.
Yes.
At least I understand it better, because in the Free State,
Yes.
they discourage deviling. So I just want
Really?
to know how beneficial is it to this when in the Eastern Cape it's okay, but in the Free State it's not okay. Thank you.
Yes, I obviously can't speak to the Free State. My experience at the Port Elizabeth Bar, I've been very fortunate. It's not only the sulks that allow deviling, but let me explain first what deviling is. There are two ways that juniors come on board in a matter. The first is being appointed as a junior counsel on brief, and the second is working behind the scenes without their name on the brief. This second way is deviling. So what it is, for example, if I were a junior, is I would be sitting in my chambers and I'd get a call from a more senior person saying, I need help researching, I don't have time, can you look something up for me? Then I would go and do that research for them and they would bill me out of their own pocket. So the client may or may not ever see that bill, depending on how the senior bills. And that is empowering in the sense that I may never have done research in that particular field, but for the senior, junior, or silk calling me in to help. What is also beneficial there is you can make a name for yourself with the more senior members of the profession without embarrassing yourself in front of the attorneys, or at least running the risk. I actually benefited a lot from that sort of work, and right up until the day I took silk, I was still deviling. It is helping out more senior people when they simply don't have the time or the capacity. I think it is fundamental to a junior's practice, and it is fundamental to more senior members, because one cannot always bring a junior on board. Sometimes the clients don't have money, the lay clients. And I still need the research done, but I can't bill out at my rate. So getting a junior who's charging a third or a quarter of my rate to do the research saves everybody money. And it gives that junior the ability to learn new things and to prove themselves. So it is fundamental in the practice of advocacy.
Thank you. Just to follow up, the issue I have with it is that the other person you bring in
Yes.
is not supposed to be seen by clients. So this is the problem that I have, because she can't be seen. How do we expose them to clients to say this is one advocate, black advocate, who actually did the work for me?
Yes. What does happen sometimes is it becomes apparent later on that the matter may in fact require more than one counsel. And if that's the case, what often happens is the devil is recommended as the junior because they've already done the work and they're up to speed. What also happens is if one does good work, so if one is able to prove oneself on that brief, the next time an attorney is looking for someone to do an unopposed motion or something less complicated, then that devil will be on the list of recommendations by the council because they know the quality of the work that the devil does. So it's a quality assurance process, but a training opportunity also.
Thank you, Judge.
May I remind commissioners, the agreement is one question, please. One question. And you remember we agreed I'm going to be stricter today. Commissioner Moiman.
Thank you, Acting Chief Justice. Good afternoon.
Good afternoon.
Beneke. Just one aspect from myself on the matter that you have raised as your contribution to jurisprudence, the
Yes.
Bobet SA versus Nelson Mandela Bay. Can you just share with us what is the significance of this case,
Yes.
particularly with regard to the participatory democracy,
Yes.
the involvement of the communities in terms of the decision-making process of local council? Thank you.
Yes. What happened in the Borbet matter was there was an IDP and budget process, an integrated development plan and budget process that was engaged in by the municipality in question. And what had happened was they had not involved the public in a manner that ensured that the public had sufficient say in both the budget and the IDP. And the court held that municipalities cannot accept a budget or an IDP without actively engaging constituent members of the municipality. You have to go to the people. The people are who the municipality is for. And by ignoring them or by minimizing their input, the municipality breached its constitutional and legislative responsibility to engage the members of the community in participatory democracy.
Thank you, Advocate. Thank you, Acting Chief Justice.
Thank you, Commissioner. And then Commissioner Shabangu Mdawe.
Thank you, NCJ. Good afternoon, Advocate.
Good afternoon, Commissioner.
Advocate, I'm raising this because I don't see it in your CV.
Yes.
We all know that mental wellness is a problem in our profession and as well as to our sisters on the bench.
Yes.
I just want you to share with the Commission what you are doing in the Eastern Cape with regard to mental wellness and the intention that we want to roll it out into all provinces.
Yes, what has happened is I was approached by the South African Women Lawyers Association, the East Cape branch, to participate in a series of workshops regarding mental health. This was identified as a particular difficulty for lawyers and for women lawyers. And a series of workshops were held. I spoke at the first one, which is evident on my CV, and then I hosted on Zoom the others, but engaged in discussion as well. SOLA would like to roll out the process, the workshops across South Africa, and I believe they're engaged in discussions with the SOLA National to effect this. But it isn't only SOLA that seeks to speak now about mental health issues. For a number of years, the bar in England and Wales have implemented mental health workshops, and we at the bar have in our training courses recognized that many advocates suffer not just stress and depression, but issues like anxiety or OCD, and struggle with coping mechanisms because of the nature of our practice. And so what has happened is we have started the National Advocacy Training Committee has started implementing lectures at their workshops as well regarding mental health. And it is a problem that is wider than we wish to admit, because many of us will suffer from diagnosable anxiety or depression, but we're too afraid to talk about it because we feel that we will be judged, that people will think that we are unable to do our jobs, when just as in the case of diabetes or HIV, if one is medicated and treated appropriately, then one can function as a normal human being and function at high levels. And that is evidenced by numerous counsel who suffer from exactly what I have, but won't come and tell the committee that, the commission that, or won't tell their friends that. And I know that from personal experience because I am open and honest about my diagnoses, because I need the support of my friends and my colleagues. And so many juniors and even more senior people have come to me and are open and sharing, and I've been able to give them coping mechanisms and refer them to help when they need it.
Thank you, Advocate.
Thank you, Commissioner.
Thank you. Commissioners on the virtual platform.
Thank you, ACJ. It's Jenny Kane.
Yes.
May I proceed with my question?
Yes.
Thank you. Good afternoon, Advocate.
Good afternoon.
I see that you chaired the tax board.
Yes.
If you were placed in the tax court
Yeah.
and the parties had not raised an issue in the Rule 31, 32, or 33 statement,
Yes.
but it became apparent on the facts that a section of the relevant tax legislation was applicable, how would you deal with that in your court?
Well, my goal in the tax board, and what would probably be the same as in the tax court, if parties can settle a matter, it is more beneficial to the parties than having an outcome on either side. And so what I've done in the tax board and what I would do in the tax court is I would raise the issues, and I would allow the parties to go away and discuss it amongst themselves. And if there was non-compliance, then and they weren't able to go back and settle the issue or seek remedial action without recourse to the court, then I would act in terms of the legislation. But my preference would be that the parties be given an opportunity to go away and attempt to achieve what had not yet been achieved.
Thank you for the answer. Thank you, ACJ.
Thank you, Commissioner. I think we have come to the end of this interview. Thank you very much, Ms. Beneke.
Thank you so much, ACJ, and good luck with the rest of the interviews.
Thank you. You are excused.